Sorry.
Okay, so welcome all. Good morning, good afternoon, good evening, depending on your time zone. Welcome to our third seminar this semester on Barrett, the US Supreme Court, Just a Justice. We have as our guest speaker Marcia Cole. She's a journalist. She's the chief Washington correspondent for the National Law Journal, covering the US Supreme Court and national legal issues. The other professor leading the discussion with me today is Professor Antonio Marchesi. He is Associate Professor of International Law at the University of Teramo in Italy, and he's an adjunct professor at the American University of Law, teaching international human rights and international law of peace and war. He is former president of Amnesty International in Italy. And we would like to welcome our guest and thank her a lot, given the special circumstances we are in, and for her time and for her availability. She will start with a brief introduction of the US Supreme Court. Then we will have some questions directed to her before opening the floor to questions and answers from the audience. So Marcia, thank you again for being with us today, and I leave the floor to you.
Well, thank you, Irene. And I'm very thrilled to be with all of you today. It's sort of a gloomy day, and it's been now considerably brightened by meeting your professors. I wanted to just start by telling you a little bit about the Supreme Court, more recent history. I would say that for more than half a century now, the Supreme Court has had a conservative majority of justices. And generally throughout that half century, there has been at least one justice who has sat somewhat in the middle, what we often call a swing vote, a justice who is conservative, but has maybe a strong libertarian streak that would lead that justice to join with justices on the left, the liberal justices, to form majorities on certain issues, often social issues or civil rights issues. The court has also been relatively stable in terms of personnel over that half century until most recently. In 2005, the current Chief Justice, John Roberts, was confirmed by the US Senate. And at that point, the court started to have quite a bit of turnover. Until his confirmation, the court had not had a change in personnel for at least 11 years. And that was the longest period in modern history that had gone without a new justice arriving on the bench. But from 2005 until the current day, the court has had 7 new justices. That's 7 of the 9. And that's a huge amount of turnover. And I've been told by some of the justices, there's this old saying that with each new justice, it's a new court. And also, one justice once said to me, now that may be true, but the practical impact is that justices who you could rely upon for a vote in certain areas may be gone. And so you have to begin to form new alliances. The last justice who really was in the center of the court was Anthony Kennedy. After he left the court 2 terms ago, you had John Roberts considered, the Chief Justice, considered the median justice. He's very conservative, but yet he's also what we call an institutionalist. He cares about how the public views the court. That doesn't mean that he votes in ways to be popular. It's just that he knows that in the United States, the ability of the Supreme Court to convince the people to follow the rule of law as they lay it down after interpreting the Constitution and federal laws really depends on the court not making hard, I guess what you would call sharp jolts to the legal system by changing the law quickly. And in a dramatic way. So he tends to want decisions that are narrow and that move the law in small steps so that the public can absorb what is happening. But in the last year, in September, Justice Ruth Bader Ginsburg died. She was on the left side of the court, a very staunch liberal, probably along with Justice Sonia Sotomayor, the most liberal justices on the court. And with her death, that presented President Donald Trump with another opportunity. He had already got 2 nominees on the court, Justices Neil Gorsuch and Brett Kavanaugh. So he now had a third opportunity to put a very conservative justice on the Supreme Court. The timing was awful. It was so close to the election, yet the Republican leader of the Senate, Mitch McConnell, has been very committed to putting Republican nominated judges on all of the federal courts. And he decided, over a lot of opposition and unhappiness, to rush through the president's nominee. And so President Trump nominated Amy Coney Barrett, who was a law professor basically for a number of years. She didn't practice law very long, but she was a respected academic. At Notre Dame, and her confirmation was part of the opposition that the Democrats in the Senate, many members of the public, all felt that this should have waited. It was so close to the election. The confirmation should wait until a new president or the same president was reelected. And the people then would show through their votes in the election who they wanted to be nominating the next justice of the Supreme Court. But as I said, the Senate Republican leader has been very committed to putting judges and particularly justices on the Supreme Court of a certain philosophy, and he just plowed ahead. He had the votes in the Senate, and Barrett was confirmed as the new justice on the Supreme Court. Now that changed the composition of the court rather dramatically. The court has been divided by ideology, 5 conservatives, 4 liberals, until Justice Ginsburg's death and Barrett's confirmation. There is now a 6-3 breakdown, 6 conservatives, 3 liberals. And really the impact of that is going to be on Chief Justice John Roberts. He may no longer be that center of the court. He may no longer have the power to control how far and how fast to the right the court moves the law. And so we're at a point now where we're waiting to see basically what happens with Justice Barrett. You know, what is she going to do on certain issues? And we just did get a taste of that, and I know we're going to be talking about it. So I don't want to, spill it all in the first 5 minutes. So I'm going to stop now, and maybe we can talk a little bit about what has happened and what is ahead.
Thank you very much. This is the perfect introduction to our topic. Indeed, we cannot refrain from starting from what just happened on Wednesday night, because the pendulum just swung on the other side, and the Supreme Court overruled the previous decisions that were took in California and Nevada. So could you elaborate on that, because that brings out the question about, can we separate politics from law? Can we separate politics from justice? Because they're not just judges, they are named justices. So, all the debate, the death of Ruth Bader Ginsburg was about, how liberal she was. But if she could seat on the Supreme Court, then you could argue, well, why not another justice with other views? Why only some views are legitimate? So the question is, then are the rulings really political rulings? Because you also confirmed that, there is a conservative versus liberal balance. Therefore, it seems that the Supreme Court is actually very political in nature. or am I wrong?
This is sort of the age-old question. Are they doing politics or are they doing law? And I have to say, when I speak to non-legal groups around the country, and I try to do a little of that, that's probably the question I get most often. And I try to say, well, we are talking about ideology here, which is a little different than partisan politics. We're talking about people who have a certain philosophy, a certain way of approaching interpretation of the Constitution and statutes, and that takes them in a certain direction. You have conservatives on the Supreme Court who believe in what we call originalism. When they want to interpret the Constitution, they look at what the understanding and the meaning of the words were at the time the founders drafted the Constitution. And also, those conservatives are textualists when it comes to interpreting statutes. If the wording is clear, then that's the end. You don't look at legislative history. You don't really look at the intent of Congress. You look at the words, and if the words are clear, that's what the statute means. And then you have others, and they tend to be more liberal justices who say, well, originalism is fine when you're looking at the Constitution. You can look at the meaning of the words at the time of the founders, but you can't stop there because times change. We evolve as a people. Technology evolves. The founders could never have imagined cell phones or even, airplanes. So they say you have to look at what was originally thought and then apply it to the times that are before you. And as far as textualism goes, yes, if the words are clear, then we can stop there. But the words are not always clear, or they're not always clear to me or you. And so you have to look for other sources to help you interpret what that statute means. And that may be looking at what the members of Congress wrote at the time they were drafting the statute. You look at the debates, and someone like Justice Stephen Breyer, who is a liberal, he also looks at the practical impact. It may not decide the case for him, but he very much wants to know how one interpretation versus another will play out in terms of the American people and their lives. So, you have different approaches to interpreting the Constitution and statutes, and they're conservative and they're liberal approaches. It's very hard to say that, they practice politics. I often say, these justices, they come on the court not as blank slates. They bring with them their lifetime experiences, their experiences in law and their experience in life. And that's what they apply. If the American people are going to elect a conservative Republican president, then they are going to, if he gets or she gets the opportunity, they're going to nominate a conservative justice, and the same with a liberal president. So I tend to look at it more as ideology than I look at it as partisan politics. It's who they are. Sometimes though, I sit there in the courtroom when we can sit in the courtroom, and I do wonder, because there are some cases that they take that they don't have to take, and they want to change the law in a certain direction. And I saw that fairly recently with a case involving the First Amendment and unions. And for many, many years, over 40 years, the Supreme Court has held that it doesn't violate the First Amendment free speech rights of non-union members to have to pay what we call fair share dues to the unions that are required to represent them during collective bargaining. And for 40 years, that was the Supreme Court's precedent. And yet, recently, in 3 separate decisions, really instigated by one justice, they began to question that precedent. And they the conservative justices sort of laid out a roadmap for challenges to that precedent, that 40-year-old precedent. And of course, they got the challenge they wanted, and they changed the law. They overruled the precedent. They said, okay, well, now it is unconstitutional. And when I see that abrupt change after 40 years, it does make you wonder if they're doing politics or law. I often, think back to something that Justice David Souter said. He has retired from the Supreme Court, and he was speaking to a group at a town hall in the state of New Hampshire where he lives. And he was asked that very question, Irene, that you posed. Is it politics or is it law? And, he didn't say, it was either, but what he said was, on the Supreme Court, you're looking at questions that involve the application of principles. And the Constitution is not always clear, which principles should apply. And I'll give you an example of the campaign finance case, the Citizens United case, that many Americans despise because it allowed corporations under the free speech guarantee of the First Amendment to contribute independent expenditures to campaigns. It ultimately opened the door to a flood of money in our elections. But at the time, Justice Souter said, okay, you had 2 competing principles here under the First Amendment. You had the principle that with free speech, corporations should be able to speak, through their money and say as much as they want to say, as long as these were independent of the candidate. But then the competing principle for most of us was, yes, but it shouldn't be so much speech that it drowns out our right to speak. And so how do you balance those competing principles? And he said, ultimately, what you and I have to do is decide whether the Supreme Court's choice of which principle to apply is convincing. He said, you've got to read the decisions, and you'll read the majority opinion, you'll read the dissenting opinion, and then you decide if you think they made the right decision and for the right reasons. Chief Justice Roberts has often said that the Supreme Court is the most transparent of institutions because we put everything we're thinking in writing. Well, I'm not sure I would say it is the most transparent of institutions, but it does lay it out there. And we as a nation have to decide, whether, we agree with the way the Supreme Court applies those principles. And the language of the Constitution also is not always clear. Our Fourth Amendment says you have a right against an unconstitutional search or seizure. Well, what is an unconstitutional search? And so you have to, the court has to sort out the circumstances to decide when a search goes too far, when a warrant is required before police can search you. And so those are the things that the Supreme Court has to work through. And as I said, it's sometimes hard to tell if it's politics or law, but I do believe that a lot of it is ideology. We get who we vote for as president.
So just to follow up, before I give the floor to Antonio, sorry, so if you read the opinion of the Supreme Court that was given on Wednesday,
yes,
the opinion of the conservative justices was that actually religious institutions were sort of treated differently, actually were sort of punished compared to secular, shops and other
Yes.
kinds of, I don't know, casinos that were left open and so on and so forth. Whereas other justices said that's not actually true because lots of gyms were closed and so on and so forth. So if you actually read the opinion, it's still very difficult to understand whether it's political or not.
It is. And part of the problem is, as you pointed out a little earlier, they had two decisions involving California and Nevada and religious institutions in those two states that were looking to get out from under their governor's COVID-19 restrictions. And the court in those cases, and those were 5-4 decisions, refused to let the religious institutions have their way. They refused to issue injunctions blocking the governor's orders. Those two cases had Ruth Bader Ginsburg still on the bench, and Chief Justice Roberts joined the left side, the liberals, to make that 5-4 majority, okay? Now we have Amy Coney Barrett on the court, and the court gets, right after her confirmation, the timing, they sense either victory or a more sympathetic court now, and you have a 6-3 majority on the court. And the New York, the Catholic Diocese of Brooklyn and the Jewish synagogue, they come in with emergency applications. They want injunctions blocking Governor Cuomo from the restrictions. And you end up with a 5-4 decision. This time, the opposite of the California and Nevada cases. And the person Chief Justice Roberts is in dissent. There is a fundamental difference here, aside from what the actual restrictions say on the churches. There's a side of the court that Chief Justice Roberts represents that believes in this type of a crisis, a pandemic, you don't turn to, and the Supreme Court itself doesn't have the expertise that the governors are looking at to make these decisions. The Supreme Court should defer to accountable, elected state officials to make decisions. The Constitution also entrusts the states, not the federal government, not the Supreme Court or the federal courts, but the states, with the responsibility for the health and welfare of their residents. That's the one side. The other side of the court is the very conservative side of the court that has, in recent years, and often with Chief Justice Roberts, been very pro free exercise of religion under the First Amendment. But in this situation, they still carry forward that very strong commitment to the free exercise of religion. And so they don't see Chief Justice Roberts and the liberal side view that you should defer. They think that they can sort through these restrictions and decide whether they run afoul of the Constitution's First Amendment protection of the exercise of religion. Justice Alito, who I think wrote the main opinion that we saw the other night, it was not a signed opinion, but I think he wrote it because I sense a lot of the language was his. He very recently gave a speech before a very conservative group called the Federalist Society, in which he talked about how religion was becoming a disfavored right in America. And he painted a very dark picture of the dangers, and he also spoke to the pandemic restrictions on religion, that they were unprecedented. And it was puzzling to me because, religious institutions have been winning at the Supreme Court in these challenges for, a number of recent years. But still, there is this side of the court that believes that it is becoming a second-class right in America, which many of us just don't see. But that was the, that was the breakdown here. And yes, it does give the appearance of politics because of Justice Barrett. She was the one who made the decisive vote, the 5-4, because Chief Justice Roberts moved to the left, to the dissenting side. And that was the first indication. And religion, again, not to make this too political, but her religion and what she has written about religion was very much a factor during her Senate confirmation hearings. There was opposition, and it was very careful opposition because we don't have a religious test for federal judges. And many senators, Democratic senators, didn't want to appear to be, imposing a religious test on her. But the truth is, she has written so much and lived her life in such a way that it was a legitimate issue to at least discuss. And so it appeared that the decision Wednesday night kind of played into their concerns about Justice Barrett. She did not write at all. I mean, there was a lot of writing in that decision Wednesday night. It was more than 30 pages at midnight. Thank you, Supreme Court. Journalists everywhere were not thrilled that evening to get the phone call, but there were more than 30 pages, 5 separate opinions, but she didn't write anything. So we don't know where she stands, well, we know where she stood with the majority, but we don't know what her thinking was. And it would be really nice to have had her write something like the Justices Gorsuch and Kavanaugh also wrote for the majority. And so we had a sense of where they were coming from. And of course, we had 3 dissenting opinions, and we knew where they were coming from. But Barrett didn't write. And, maybe she was being cautious because she knows that religion is something that she's being watched about. She's also being watched closely for any votes she takes on election fallout, the presidential election. The court is still getting certain cases, and thus far, the court hasn't had to rule yet. So it may be she's just sitting back a bit before she writes in these areas. But she will be called upon because they also have a very big religion case this term that she sat in on during the arguments. So she will have to vote. It involves Catholic Charities of Philadelphia, Pennsylvania, which is challenging Philadelphia's non-discrimination requirement when it comes to placing foster children with foster parents. The Catholic Diocese does not want to place these children with same-sex couples. And so this is a clash between our non-discrimination policies and religion. And so it's going to be interesting to see not only where the court comes out, but where Justice Barrett comes as well.
Thank you very much. I leave the floor to Antonio.
Yes, this is, for a European lawyer, I think this is fascinating, but also slightly disturbing at the same time. Yes, and in fact, the fact that the Supreme Court should be such a battleground, whether it's a political battleground or not, but I mean, after all, it is a battleground between sort of different ideas of society, is one of the striking aspects. Together with the voting system, but that's not on the agenda today. I was thinking about sort of what may be a difficult comparison, but interesting, that is between the US Supreme Court and the Italian Constitutional Court. Because at least in theory, the Italian Constitutional Court interprets our Constitution, has an impact, a significant impact on legislation, on the laws. It occasionally deals with highly sensitive issues as well, but it is not perceived as such a battleground. It's more like perceived as a guardian, possibly an impartial guardian of common values that are enshrined in a written constitution. So although there are many sort of things that in which the two courts resemble each other, they're perceived, at least perceived, as very different. And I wonder if this has to do with the fact that we have a written constitution which is much more recent. It's written in a language that, after all, most people can still understand, and it does sort of include an accurate picture, or fairly accurate picture, of the sort of the aspirations of Italians after World War II, which is not that long ago. In comparison with a constitution which is centuries old, maybe written in a language that is no longer that easy to understand for most people, which leaves the interpreter an enormous sort of margin of appreciation. So in the end, the written text is at least as far as I understand it, almost a pretext for a group of justices to take decisions. And therefore, that is what makes them more sort of, gives them more discretion and makes them more political. So it's an outsider's perception, but it gives the sort of the idea that what we have is a written constitution which is fairly recent and detailed, and that the justices are guardians of the values that are enshrined, impartial justices, impartial guardians possibly. Well, in this case, you have a sort of rather ancient text that leaves justices a role which is more political and less judicial. That is one element. Then I would have a lot to say as a human rights lawyer about the originalist approach, because obviously, I mean, law and human rights law and international human rights law share a lot of common ground. And international human rights law probably wouldn't exist without dynamic interpretation. It would make very little sense. Here again, we have short sort of generic texts that have a meaning only because they're interpreted in a dynamic way, taking in account sort of the evolution of society by international bodies. So the idea that you can interpret issues that relate to fundamental rights by giving the original sort of interpretation of something that was written in the 18th century from the point of view of a human rights lawyer makes absolutely no sense.
I take your points. Points are very, very interesting. I have to ask you first, let's start with your Italian Constitutional Court. How are its members appointed, elected? How is that done?
That makes a big difference. There's three groups. It's a much larger court, and they're not appointed by the executive power in the same way in which it happens in the United States. So I mean, it's a different system entirely. Yeah, they're not appointed by the president, or they're not. And also the problem is that the president has a different role in Italy. It's hard to compare, but it's certainly the way they're appointed has a lot to do with the difference in the role that then they perform.
And are they appointed for a term, or are they appointed for life like ours are?
Once again, they're appointed for a term.
Yes, yes. That's fascinating, because, you know, there's been very serious discussion. There's been less serious discussion over the years, but more recently, serious discussion about how to reform our Supreme Court. And one of the ideas and hopes would be that we could tamp down the political fervor surrounding Supreme Court nominations is by imposing term limits on them, so that you have turnover on a somewhat regular basis, and each vacancy doesn't suddenly become a battle between the two political parties over who should sit there. So that's one proposal. And And then I wonder too if it also has anything to do, but before I say this, I have to chuckle when you say, and we have an ancient text. You coming from Europe, we have a constitution that is just between 200 and 300 years old, and Europe has, such a ancient history. I have to chuckle at being called ancient, but your point was absolutely right. The Constitution hasn't really changed much. It has changed some by amendments, but there's this tremendous fear that if we ever tried to update our Constitution and had a constitutional convention, it would just be horrible. It would be such a disarray because we have such a divided country. Whether we could find anything to agree on, it would be difficult. And again, that makes me wonder too, what is Italy, does it get as divisive in Italy as it does in the United States over certain social issues, like abortion, religion, gay rights, but it does the fact that your court has a modern constitution and does have term limits, does its rulings then, does that sort of tamp down the divisiveness within the country?
Well, I wasn't sort of suggesting that it wasn't, it didn't deal with divisive issues.
Right.
But at least in my perception, it never reaches the level in which the U.S. Supreme Court reaches in having a well-known division between sort of conservative judges, progressive judges, judges that are that provide the swing vote and so on. It doesn't work like that. Which doesn't mean that it doesn't deal with issues like abortion, which are highly sensitive,
right,
or we're mentioning before. Other issues that are highly sensitive relate to, for example, adoption by homosexual couples, same-sex couples, and so on. There are a number of issues that are very sensitive, but that doesn't transform the court as a whole, as a body with an identity which is so political. In the meantime, I saw that Giorgio gave a more accurate information on the way they were appointed, which was what I was vague about. That is, you have 5 that are elected by the judiciary itself, 5 are elected by parliament, and the total is 15. So they have different.
5 by the president.
Yeah, and 5. The last 5 are by the president. But even then, the president is not the head of the executive. And also, there are 15 judges with different that are nominated according to 3 different
systems,
different constituencies. So that point, that is the way they've nominated, certainly goes a long way in explaining at least some of the differences.
And that's also very interesting because one of the reforms that's being discussed too here is to increase the number of justices on the Supreme Court. Of course, when that's proposed, whoever proposes them, whichever party mentions it, it's been accused of trying to pack the court. We go round and round and we go nowhere on this. I'm not quite sure how we get out of this. And also, there are a lot of hard feelings between the 2 political parties because of how certain nominees have been treated over the years. And it goes all the way back to the first confirmation I ever covered in 1987, the confirmation of Robert Bork. And at the time, Bork was a federal appellate judge, and he had written a lot, and he was very open about his positions on how he interpreted the Constitution. He answered questions from senators, And ironically, well, anyway, he did answer questions and ignited debate all around the country at the time. One of his more controversial positions, and he did believe in originalism, was that there was no right to privacy in the US Constitution. And that just was, whoa, you don't say that to an American, that we don't have a right to privacy. Oh my God, no. And he was defeated on the floor of the Senate. The Republicans really were angry about that. And the current Republican leader in the Senate, he was there at the time, has been on a mission ever since. And I think it's almost like a payback mission to try to get as conservative and young justices and judges as he possibly can. And he has had the votes to do that. So there's just, the whole thing is a mess. And the advent of television here, televised hearings, also has increased the temperature of these confirmations. There was a time in our history when they weren't televised, obviously, because we just didn't do that. But also nominees didn't even appear before the Senate Judiciary Committee. They just sat outside the room and waited, or they went before the committee, no television cameras, and it wasn't as intense as it is today. And I think the media has contributed as well to that. And now if you're nominated to the Supreme Court, every corner of your life is being revealed. And you're giving people a lot of fodder to chew over and become divided about. So it's really, it's hard to know where to start, particularly since it would require the Congress to get together to decide that they want to change it and how to change it. And so we have what we have. And I look at your constitutional court and I see why you are less political, less divided than we have. And it is because of your system, how they're appointed, the term limits that they have to live with, and the number of justices. It really can make a huge difference. So why don't you come to the United States and talk to the US Senate and say there's a better way to do this, folks.
Martha, going back to the hearings you were mentioning earlier, it was very interesting, the hearing of Amy Coney Barrett, because despite all the discussion about her beliefs, her religious beliefs, and how those could influence her judgment and her rulings, she didn't say a lot. She actually almost tried to avoid any answer. So she was asked actually about an article she wrote in 2014 on the Texas Law Review. And in that particular article, I have to read it because I quote, she said that when a justice's best understanding of the Constitution conflicts with a precedent of the US Supreme Court or case law, it is more legitimate for her to follow her preferred view rather than apply the precedent. So of course then the question was, would this imply that she would be willing to overrule the Brown versus Board of Education or the Roe versus Wade, so segregation and abortion, and that begs the question about what is a precedent and what is a super precedent, because referring to Brown versus Board of Education, that is the segregation, abolition of the segregation, she said that's a super precedent. But when she was talking about Roe versus Wade, she said, but that's just a precedent, it's not a super precedent. So subtitle that could be overruled. So could you explain, a bit
of precedent? That was the creation of a Pennsylvania U.S. Senator, Arlen Specter. He created the terms super precedent and super duper precedent. And what she told the Senate committee when she was questioned about precedents was that Brown versus Board of Education would be considered a super precedent because we could never imagine that while there could be a case that would try to overrule Brown, the Supreme Court just would never do that because it's just unimaginable that we would ever return to the days of legal segregation. She said that Roe, on the other hand, can't be considered a super precedent because it is still being debated and it is still controversial. And there are decisions still coming that involve, fallout from Roe v. Wade. And so it is a precedent of the court that has been upheld several times. But if she faced it, she said, she would have to apply, as they do whenever they're asked to overrule a precedent, certain factors like, is it workable? Is the decision still workable after X number of years? Is it right? Was it a correct decision? There's some on the court like Justice Clarence Thomas, who believes that if he thinks a precedent was wrongly decided, then he doesn't care about the other factors. You just overrule it. He doesn't really believe in a doctrine that the court tries to follow called stare decisis. It's a Latin term basically saying you stand by your earlier decisions, unless these factors show that it needs to be overruled. And there are those on the Supreme Court who believe very strongly in stare decisis and those who don't. And Thomas is one who doesn't believe in it. He just, as I said, if it's wrong, it goes, we throw it out. But she said she would apply all the traditional factors. And there isn't much you can do when they say that. They all say that, especially about Roe v. Wade and abortion. They all say that. But it got to the point, in our country that the lower level judges that were nominated refused to answer the question whether they believed Brown versus Board of Education was correctly decided. And that was just amazing. They so feared public repercussions of even answering that question that they just refused to say. They would say, I can't talk about old cases because new cases may come before me, and I don't want to appear to be biased in any way. And yet it was Brown. And you even had John Roberts when he was being nominated. He didn't have a problem by saying, yes, Brown was correctly decided. But still today, the fact that Brown could be controversial is rather stunning. And shame on those nominees who wouldn't say, yes, it was correctly decided. But she answered that question about precedent the same way all of them do. And that is not making a commitment, but will apply the standard factors if a case comes before them. So she really was not very forthcoming on anything. And, I've come to expect from these nominees that they're not going to answer specific questions about cases, that either old cases or case issues that might come before them, which I understand that from the point of judicial ethics. But I don't understand why she wouldn't answer a question like this. She was asked, is voter intimidation illegal? She wouldn't answer that. And yet the law is so clear that it's illegal. That was amazing to me. And there were a couple of other questions too about the transition. Right, exactly. Yeah. And all I could think was, that's not showing a lot of courage, because it was pretty clear that how she feared that if she answered those questions, that President Trump wouldn't like it because he took certain views that, voter intimidation isn't illegal. Well, one could say President Trump has engaged in considerable voter intimidation with some of his tweets and other comments recently. So I thought that didn't reflect very well on her. Those were very straightforward legal questions that she could answer without any problem. So what does that say about who she is? I don't know. As I said, we're going to have to wait and see. Wait and see. Oh, also, Irene, I'll point out too that the hearing was interesting because the Democrats on the committee knew they didn't have the votes to block her nomination. And so what they had to do was try to present to the public, try to help drum up opposition at least and pressure on their Republican colleagues by selling the public on her being a threat to certain things. And very much in the forefront of American debate too is healthcare. And so the future of the Affordable Care Act, which was enacted during the Obama administration and has been, after a rough start, a huge success for people who need affordable health insurance. And particularly now in a pandemic where people have lost jobs and lost their employer health insurance, it's been a lifeline for many people. And she had written an article in which she challenged and questioned and said that she thought that when the Affordable Care Act first went before the Supreme Court and the court upheld it in an opinion by John Roberts, a 5-4 decision again, she thought the dissent had the better argument and the dissent would have torn down the entire act. And the court now has another case before it that really involves the Affordable Care Act's future, its fate again. And it's challenged by Republican-led states. So the Democrats on the Senate could only present her as a threat to that her vote based on what she had said could make the difference in the future of health insurance for many Americans. So they didn't have much they could do really to try to block her her confirmation. They had that, and they also had the fact that we actually were in the middle of an election, and there were polls showing that the American people felt that any nominee should be dealt with after the election. But that didn't happen, obviously.
May I? Thank you so much for these last remarks. I found them really, really interesting. I have a question. Well, actually, 2 questions. The first one is the following. I have the impression that, you correct me if I'm wrong, but we are really witnessing a progressive, we may say, evolution of American, the public sphere looks very much, it seems like it's dominated by infotainment, right now, even in, in the context of this polarization that we witness. And I think that the hearings of the last 2 justices in the Supreme Court were very much an example of that. Perhaps I don't think that we will ever reach the peak of the Kavanaugh hearings anymore in terms of drama, right? But do you think that, you don't know, that's true. But do you think that this trend is here to stay? Would you say that this sort of, this type of sort of a spectacularization of hearings, really, and controversy surrounding hearings? This is the first question. And the second question would be, if you dare, I know it's very difficult to make predictions, and we should all be very careful. But what do you think, how do you see, so you have a long experience, and the question would be how do you see the trajectory of Barrett? What do you think she's gonna go next? Because as you said, she was very cautious. She didn't answer very, banal almost questions, right? That she could have answered quite easily, right? Yeah. So what would you see could happen?
Okay. I think you're right about the role of all kinds of media on these hearings. And I don't think that is going to change. I think as long as we have 9 justices appointed for life, although the Constitution says good behavior, it's going to continue that way because of the hyper-partisanship of our Congress right now, and to a certain degree, the American public. And the just the proliferation of social media. I mean, the fact that so many young people get, their news from sources like Twitter and other, and you look at how local newspapers are dying around the country. It's a pervasive force, and I don't see that changing. So that combination is going to continue to make a Supreme Court vacancy a very high profile, controversial issue. And if the seat, the vacancy would tip the court one way, in one direction or another, then that really heightens the controversy and the emotions surrounding it. And when you talk about Barrett and looking ahead, boy, you're right. It's very hard to make predictions because there have been justices appointed, and I'll give the example. President Eisenhower, rock rib Republican, he appoints William Brennan, the most liberal justice probably in our history, and he didn't know it at the time. So you just don't know. Once they're free, once they've got that job for life, they can do, they can move however they want. And there has been movement over the years. Even Justice Souter, he was appointed by Republican President George H.W. Bush, and another conservative. And Justice Souter was a conservative at the start of his term, but he became increasingly liberal in terms of his votes. So what is happening here? Well, consider Justice John Paul Stevens. He retired from the court in 2010. He was considered the leader of the liberal wing. He was a conservative. He was appointed by President Ford. And when he was asked about that title, he said, "I never changed. The court just became more conservative around me." And, that's true. It did. It became more conservative. So it's hard to predict what will happen. But I will say that since President Reagan, the machinery around nominations has become extremely sophisticated. You don't have, like you had when Souter was nominated, he was called a stealth candidate because he hadn't written much. He had been on a federal appellate court for a short period of time. Nobody really knew what Justice Souter was going to do. But Reagan really, his people around him, they knew, and this is where Republicans have really surpassed Democrats in terms of knowing that the courts are really important, especially when you have divided government and you can't get much done. You can go to the courts. You're going to find somebody who will bring a challenge, and so you'll go to the courts. So they knew the courts were important, and they had to get people on the court who shared their philosophy, their ideology. And so there really were the idea of a stealth candidate has disappeared if it's a Republican president, because they go through their writings, their background, they talk to people who know them, so they really know what they're getting. And I have to say, yes, John Roberts has surprised us in recent terms, but he's sort of an old-fashioned conservative. So he applies, his those standards and those principles for the most part in his decisions. But the Kavanaugh, the Gorsuch, and maybe the Barrett, they are very, very conservative. And so I'm less optimistic that you're going to see the kind of movement, which generally is from right to left, not from left to right, that we've seen over the years. And I may be wrong, I've been wrong before. So, stay tuned.
Thank you. That's a good piece of advice always.
Antonio has a question.
Yeah. Yes. The question is about how relevant is what happens in the rest of the world to the decisions made by the U.S. Supreme Court. I had only one case in which I had sort of some involvement because of my own work in what the Supreme Court does. I contributed to an amicus curiae brief in the Roper-Simmons case, which was a case about abolition of juvenile death penalty.
Yes.
And I remember at the time there was a heated discussion on whether any relevance should be given to the trends throughout the rest of the world.
Yes.
And at the end, they did reference, developments in other countries significantly, but it was a narrow majority. And I remember, I think it was Justice Scalia saying, oh, we should never allow other nations to tell us how to interpret our own constitution. So the impression is that, at least insofar as conservative justices are involved, the U.S. Supreme Court is used more like sort of something to shield protect U.S. values from intrusions from the outside world, rather than sharing common values, which, once again, when it comes to fundamental rights, to basic human rights, is quite disappointing from my point of view, because they should be shared values and not something that each country sort of understands in a different way for itself. So that was something I wanted to ask you about.
I'm sure you sit back sometimes and think, where is Anthony Kennedy when I need him? Because Justice Kennedy really, and he was key in those death penalty decisions that abolished it for juveniles under a certain age. And he also was key in the gay rights decisions that the court has issued. In fact, they used to call him the gay lawyer because he wrote those decisions. But he had a very broad view of the need to look at international law. And this is an issue that I've never really understood, the fear. Many nominees are still asked by Republican senators, would you allow foreign law to influence your decision about the US Constitution? And of course the answer is, oh, of course, no. But there are those on the court who do believe, and I think Justice Breyer is another one, who have an international perspective, gained from years of study. He is, Justice Breyer, speaks fluent French. He teaches in France. He's an Anglophile, he's married one. And he has this very broad perspective, and he will look to it. But to me, there's a difference between, looking at international law from other nations and using it to decide a case. They don't decide a case because Italy has decided a similar case. But as Justice Breyer has said, there's no reason why you can't look at how the Italian court decided a similar case to learn from it, and then look at your own constitution or laws and try to see if there's similarities. The same as saying, that foreign law, that I base my decision on Italy law, Italian law. That's not the same. So Yes, unfortunately, as you point out, it is a conservative suspicion of foreign international law when it comes to looking at Supreme Court cases. Now, there are cases that come to the court that it has to look at international law, cases involving foreign adoptions, cases, they're dealing now, they have cases involving the Nazi era in which Jewish art was stolen. And they've got to do that, and they will do that when they have to look at the Hague Convention and what it has done. And that's specific to a particular case. But you're right, there is that suspicion, and again, I said it's really on the conservative side of just even taking a look. We've got an issue for the first time before us. Well, let's take a look at how other countries, other courts abroad have dealt with it, if they have. It's just, it's a narrow-mindedness. What can I say that some hold, but not all.
Another divide.
Yes, another divide.
Yeah.
I think it was Alexis de Tocqueville who wrote at the very early forming of the United States that every issue that there is eventually comes to the Supreme Court or the courts. It's just the way we are. We're a melting pot, so we have many different opinions.
I would like to let those who are following us that we can open the floor to questions and answers from the audience. And in the meantime, while we gather the questions, I would like to ask you a small question. Late Justice Scalia recused himself when the Supreme Court had to rule over the fact that public schools in the US were pledging allegiance to one nation, one God, because he made a public speech in which he actually expressed his own personal opinion. So since Justice Barrett actually expressed her personal opinion on the Affordable Care Act, do you think it would be expected for her to recuse herself, because there is no explicit rule about justices when they must recuse? So I think it's more a personal decision, if I'm correct.
It is definitely. The Judicial Code of Ethics does not apply to Supreme Court justices, but they do say they all follow it, and they will discuss with their colleagues if there is a recusal question that they're unsure of. I think I know lawyers are very reluctant to make a motion to recuse a Supreme Court justice, and the justices themselves are reluctant unless it's an obvious conflict to step aside, because there's no one who can fill in for them, and that creates the possibility of a 4-4 split in which the case is not decided. The lower court opinion is left in place, and they want to, do their jobs. They want to decide cases. So they're very reluctant to step aside. There was no motion for her to recuse. Excuse me. I would think that she would say, this is a very different case and issue, which it is, than the case that she wrote about. So she doesn't, what she said about a decision in 2012, the case in 2020 is very different. So because of that, she can approach it with an open mind. I would expect that's what her thinking is.
Okay, thank you.
But I also point out that Justice Scalia did not recuse from a case involving then Vice President Dick Cheney, with whom he went duck hunting often. And the case that came before them was titled with Cheney's name in the case. And it was very controversial. He ended up writing an opinion about why he wasn't going to recuse. But he could not get away from the public statement about under God and the Pledge of Allegiance. So that was a no-brainer, I guess, for him. And there also were questions about whether Justice Ginsburg should recuse when she had made comments about then candidate Donald Trump that were not very positive statements, which she later apologized for, but she has sat in on many Trump cases.
And also because she expressed her views about the taxes, disclosing taxes about President Trump. And then when the Supreme Court was called, they said that she didn't recuse herself. But you could argue that expecting the president to pay taxes is not the same as expressing opinions about the Pledge of Allegiance or about religious freedom and individual and collective rights. Expecting the president to pay taxes, I think it should be uncontroversial even for a justice.
You would think, but we still haven't seen his taxes. We still haven't seen his income tax reports. Every president before him has released them, but not Donald Trump. So, but a grand jury in New York might get them. We'll see. We'll see. So.
Okay. So I think our students are quite shy because I don't think they feel very confident with the topic.
No,
I see some 9 chats. Are there? I don't know those aren't questions.
Yeah, no, there are more comments. Actually, Lauren, she was commenting that I suppose when we were talking about the gender issue and the voter intimidation, yes. She said that this is why some women are terrified. She says the reality of religion shaping law in the U.S. is all too real, regardless of the First Amendment. So she was she inserted the comment also when we were referring to Roe versus Wade and whether it was a super precedent or not. Yes.
Yeah.
That's going to be interesting. Abortion is always before the Supreme Court, and they have right now a case out of Mississippi that would ban abortion. I believe it's at 20 weeks, which is clearly a violation of their precedent in Roe v. Wade and Casey, which followed Roe v. Wade. And I think the court, now that it has a 6-3 majority, is going to continue to get these head-on challenges to Roe v. Wade. And that case from Mississippi, they've had for a while on their docket, have not done anything with it. They keep rescheduling and rescheduling whether they're going to deny review or grant review of the case. And I'm not quite sure what's going on with that. Usually when it takes them a long time to decide whether to deny or grant review, somebody is writing. It may be a dissent from either the grant of review or the denial of review. But that's going to be an issue very interesting to follow now that she is on the court and it's a 6-3 court. I think another issue that we should watch is going to be gun rights, the Second Amendment. The court clearly has, I think, 4 to 5 justices who want to get back into gun rights because they think the lower courts have been too lax in protecting the Second Amendment right to own a gun. At the end of last term, they turned away 10 cases that raised various issues from the gun rights perspective. And they had enough votes. It only takes 4 votes to grant review of a Supreme Court case. But I think they weren't sure at the time whether they had a 5th vote to form a majority. So they turned those cases away. And Clarence Thomas, who really wants to get into gun rights again, he has called the Second Amendment the Constitution's Orphan Amendment. Like Alito believes that the First Amendment free exercise right is a disfavored right. Thomas thinks the Second Amendment is also a disfavored right in this Supreme Court. So I'm going to be watching that area of the law as well to see if Barrett will make a difference there. And then certainly, when you think about cases that were decided 5-4 in the past, the high profile cases like abortion, Second Amendment, you also think about gay rights and what's going to happen there. And as I said, we'll get some indication of that in the clash between religion and gay rights in the case they've already heard arguments in. So there's lots coming that should reveal more about who Amy Coney Barrett is as a justice.
Mm-hmm. Do you think that this will affect also rulings on the environment, or the interests of big corporations, or not?
Oh yes, definitely. They do have a case right now in which the city of Baltimore, Maryland, sued major oil companies, claiming that their pollution created an illegal nuisance, and this is climate change. It's a very technical kind of case. It doesn't deal with it head on, but those cases are coming. And that was another question she wouldn't answer during her confirmation hearing, whether she believed climate change.
Is real,
and,
yeah.
And as you pointed out, right? So I think we're going to have to watch that as well. And one of the key precedents was 5-4 that upheld or said that the Environmental Protection Agency did have the right or was required under the Clean Air Act to monitor and regulate emissions. So that could be in danger if there's a different feeling if it comes up in the context of climate change. So yes, I think that's going to be a definite big issue facing the court at some point. And there are always big business cases, consumer-related cases, union-related cases, statutory-related cases. So as I said, Alexis de Tocqueville said, every issue in America goes to the courts. So we'll see what happens with this new 6-3 majority.
Speaking of this, we actually have a question from a colleague,
Okay.
Giorgio Petit. He asks, so speaking of, what's gonna, reach the court. So he asks, Justice O'Connor regretted her vote on Bush versus Gore. Do you think that after that case, the Supreme Court will be more cautious when intervening in vote count dispute?
Yes, and I think we're already seeing that. They've had a number of emergency petitions related to the current presidential election that they are basically sitting on. And I think the memory of Bush v. Gore and the fallout from that is still very alive, not only on the court, but in the American public in particular. And I'll note an interesting coincidence here. There are now 3 justices on the Supreme Court, Barrett, Kavanaugh, and Roberts, who actually worked on Bush v. Gore on the ground in Florida during those very tense days. They worked for Bush, basically, to help him win that election. Kavanaugh, in one very recent emergency application election case, wrote a dissenting opinion in which he footnoted Bush v. Gore with approval, and that led many people to believe that the way the court decided Bush v. Gore was something that he approved of and was willing to apply. Bush v. Gore has been so poisonous in terms of, from the viewpoint of the Supreme Court, that it had never cited it in any of its election-related cases for anything. It just hadn't until Kavanaugh did. And also, Bush v. Gore, the majority opinion, said at the time that that case was good, that decision was good for that case only. And yet Kavanaugh resurrected it. So who knows, as they say, where the court will go on this one, if it should face a Bush v. Gore question again.
Well, I think we are almost 1 hour and a half since the beginning.
It was a fast hour and a half. Thank you.
Yes, that was amazing. I don't see other questions coming unless Professor Sotilata and Marchesi have other questions. No? So, well, Marcia, thank you for your time. It was really, really interesting. I learned a lot personally, and it was amazing. Thank you for your time and your patience.
Oh, it's my pleasure. You all had very good questions. And I love talking about the Supreme Court. So, anytime in the future, feel free to zoom me in.
Absolutely. We will reach out until we can invite you in Rome.
And thank you.
Yes.
I would love that.
Thank you very much. And I'm looking forward to seeing you in AUR, which is a wonderful place, by the way. It's in a beautiful part of Rome. So.
Okay, good. That sounds great.
You're gonna love it.
Good.
Until
Good.
soon.
Yes, yes. So I hope all of you stay well and your families stay well, and also your students. If I haven't put them to sleep yet, I hope they also stay healthy. And
Thank you so much.
Certainly hope we meet again. Take care of yourselves, all right?
Okay.
Bye-bye.
Bye-bye. Ciao, take
Bye.
care.